what I want to talk about, I want to give kind of an overview of this case that's been before the Supreme Court. I personally have been wrapped up in this thing because I developed one of the metrics that was offered to the court as a potential measure of partisan gerrymandering. And so what I'd like to do is just give a high-level overview of what the legal background of this case has been, then talk about the opportunity that this presents for social science and actually computer science as well, for potentially measuring what a gerrymander is. Then I'm going to get into some of the metrics, a little bit into the weeds. Maybe not enough for this audience, but a little bit into the weeds about what the different metrics are that have been proposed to the court, and what they each what aspects of a gerrymander each one captures. And then I want to talk about how all of these fit into the Gill v. Whitford case that had its oral arguments earlier this month, and then kind of where we go next from there. So the Supreme Court first got involved in partisan gerrymandering with a case called Davis v. Bandemer in 1986. This is where, for the first time, the court decided that, in principle, a partisan gerrymander is justiciable, which means it's a question that the court can make a decision about. That before that time, they've been very reluctant just to be involved in the redistricting area in general. There was a lot of drama around an earlier set of redistricting cases from the 1960s. The court had to ponder very seriously whether they wanted to get involved in those cases. And then this was extending that question of redistricting to the partisan gerrymandering space. The problem that the court had was that they didn't really know a partisan gerrymander when they saw one. They didn't have a standard for identifying one. And this is kind of extraordinary, I think, because they made it clear from the dicta in the decision that they believed that such a thing existed. They just didn't know how to define it, and especially how to define it in a way that would ensure that that they didn't see a lawsuit for every single plan, and that whatever decision they made in future cases, it was defensible as a neutral principle, so that it didn't end up making the court look like it was just pushing its thumb on the scale every time. So the end result of the case was a victory for the plaintiffs, in the sense that the court said, yeah, we could decide this case in principle, but we're actually not going to intervene in this particular case because we don't know, you haven't presented us anything that seems manageable as a standard for identifying gerrymanders in the future. This from Justice White, I think, is telling. He says, the mere fact that there is no likely arithmetic presumption, such as the one-person, one-vote rule, that's the standard that came from those earlier cases in the 1960s, in the present context, does not compel a conclusion that the claims presented here are non-justiciable. So just because we don't know what the measure is right now, and it seems like the measure is not crystal clear what that measure would be, doesn't mean that there couldn't be a measure at some point in the future. But he also says the idea that any interference with an opportunity to elect a representative of one's choice, so any amount of partisan shenanigans in redistricting, the idea that that would be enough to strike down a plan would open the door, would invite attack on almost all reapportionment statutes. So that's an issue that the court is clearly very concerned about, this question of manageability. So what followed after Davis and V Bandemer was 18 years of failure, where a variety of claims of partisan gerrymandering were brought to the court, and to the courts, I should say, not to the US Supreme Court, but just the lower courts. And they never even advanced past the preliminary motions. So they were just dismissed out of hand as not being meritorious enough to even go to full trial. That string broke with the case called Vieth v. Gill in 2004. And in this case actually kind of laid, in some ways it continued the status quo of the Davis v. Bandemer case, but in some ways it altered it just slightly, and it certainly laid sort of laid out the playing field for the case that we just heard earlier this month. So the difference here was that the basic decision was the same. We could conceivably have, partisan gerrymandering is justiciable. We could conceivably have a metric for evaluating such an idea, but we don't have it yet. And so we're going to leave the door open. The difference here is that the decision became somewhat more polarized, where 4 justices said, you know what? And what's interesting is even these 4 justices, it was the conservatives on the court, even they said partisan gerrymandering is a thing, and it's probably not a good thing. So even they agreed that there was such a thing, and that in principle it could be unconstitutional. But they said that the notion that you could ever measure it effectively and in a way that could be managed by the courts is insane, and we're never going to be able to do it, so we should just vacate ourselves from this area of the law entirely. And then 4 justices they said, not only could we potentially strike down a plan, but here's my particular proposal for how we should do it. So 4 actually were ready to offer their own standards. And then Justice Kennedy embodied the spirit of Davis v. Bandemer in saying, you know what? There could be such a measure, but I haven't seen it yet.
Were any of those 4 proposals useful?
Sort of. They kind of, aspects of them emerge in some of the other metrics that I'm going to talk about. There's sort of a playing field for these metrics, and they each kind of capture different sorts of notions of a gerrymander. So it's hard to propose some idea of a gerrymander without touching in some respect on some of the metrics that have been proposed. But I'll get to that in a second. So he says, the failings of the many proposed standards for measuring the burden of a gerrymander that a gerrymander imposes on representational rights make our intervention improper. So all these standards stink. We shouldn't get involved. If workable standards do emerge, however, the court should be prepared to offer relief. There was one other Supreme Court decision on this topic between Vieth and the Gill case, the Whitford case that was just heard. That was LULAC v. Perry. It was very similar in outcome. It only came 2 years after the Vieth decision. And it was very similar in outcome to the Vieth decision. 4 justices wanted to give up. 4 had their own standards. And Kennedy hadn't seen the standard, but he thought there might be one. The one key difference in the case of LULAC v. Perry is that there was an actual concrete metric that was proposed to the court. And that was this measure that I'll call Gelman-King bias, but some people call symmetry. And it was proposed it wasn't even proposed by the plaintiffs or the defendants. It was proposed by a group of political science professors, Gary King is a very well-known methodologist at Harvard, and he and a group of others proposed this metric completely from the outside. And they proposed it in favor of neither party. They just said, here's something you might be interested in using. And the members of the court responded to that brief and discussed whether they thought it was valuable or not. But it was the first time some concrete idea had really been put on the table beyond, hey, we have fewer seats than we used to, so we don't like this plan. So this status quo that Vieth in particular established creates an opportunity for the social sciences and for, like I say, for computer science as well to get involved in this area. It presents, and I think that the opportunity was stated quite nicely by, again, Kennedy himself in Vieth. He says, technology is both a threat and a promise. On the one hand, if courts refuse to entertain any claims of partisan gerrymandering, the temptation to use partisan favoritism in districting in an unconstitutional manner will grow. Again, he's saying the temptation to use it unconstitutionally, this thing that we don't even know what it is, right? But damn it, we're sure it exists. It's out there, it's real. We just don't know quite, how to define it. On the other hand, these same new technologies may produce new methods of analysis that make more evident the precise nature of the burdens gerrymanders impose. So please provide ideas, right? That's as close as you're ever going to get with the court. So why is it that this is such a tough nut to crack? Well, I think it actually has to do with the fundamental nature of our representational system. Our system was designed to represent geographic places. It is a very district-specific concept. So in principle, if this system were operating in its ideal form, you would have people in a particular community who would elect a person that they thought would be best able to represent their interests, that geographic space's interests, and that the interests of that geographic space would be generally shared by everybody who lived there, and the only issue would be finding the appropriate person to go there and figure out how to represent those interests in this larger body that everybody feeds into, right? So very, very geographically focused. But everybody knows that's not really how politics works. It may be kind of how people imagine politics in a party-free environment when the system was designed, but that's not actually how politics operates. Instead, parties dominate politics. And parties are an inherently aggregate concept. The whole point of a party, I mean, a party can have a geographic component to it, but the whole point of a party is to find subsets of people in each district that have common interests and desires and bind them together into a more or less permanent standing coalition. And then that coalition marches together in the legislature on issue after issue after issue. And that's aggregate. It's not district-based. Now, other systems get around this particular problem by actually specifying an aggregate vote seats relationship. Like a PR system, proportional representation system, will say, hey, for every 1% of the vote, you should get 1% of the seats. And that's specified at the aggregate level. There's no district-based component to it. So the basic problem is if the votes to seats relationship at the aggregate level is not specified in law, then how can you say that a party ever wins too many seats? Right? We're not even supposed to have these things called parties. It's all supposed to be about representing places, right? But if voters care mostly about parties when they're casting their actual votes, how can you say that partisan manipulation can have no limits? And so when you think about it in those terms, that we have essentially layered a partisan system on top of a basically geographic system, you begin to understand the challenge, the struggle that the court is facing when they're trying to decide how much is too much, right? So this creates, I think, an opening for social science. It's a real phenomenon that is complex. It requires systematic, transparent measurement, in particular in this case, because the court really wants it to be something where it's defensible as a principle, right? So that when they're applying it to any particular case, they can say, well, you know what? We had this standard we developed, and when we apply it to this case, here's what it produces, right? It's not us. We're not trying to make the Republicans win or the Democrats win. It's the formula or the standard. So it's kind of a perfect fit for social science, but I think it's a challenge for the courts, and I'll get into that in a little bit. So what are the metrics that people have proposed, have put on the table? Well, the first is this one that I mentioned earlier, Gelman-King bias, sometimes called symmetry. The basic idea behind this is that equal parties should be treated equally, symmetrically, that is. So if you receive the same share of the vote, if two parties receive the same share of the vote, they should receive the same share of seats. Now, the problem, of course, is that usually parties don't have the same share of the vote. So what do you do in that case? Well, you pretend as if they actually did have the same share of the vote. And this can be done a variety of ways. One way is, for instance, if the Democrats have 60% of the vote and 70% of the seats, then you pretend as if they had 50% of the vote, and then see how many seats they get. If they have anything other than 50%, then there's potentially a problem. Similar idea would be to, if they won 60% of the vote, to say, what happens if the Republicans won 60% of the vote? Do they also win the same vote share or seat share that the Democrats did when they had 60% of the vote? And there's a variety of versions of this. The most common, I think, is just seeing what happens at 50%. You can also you can plot out. If you think about sort of shifting this distribution of districts around and seeing how many seats flip as a result, you can actually plot out that. Yeah.
Are you going to get into the electoral college?
Maybe in the Q&A.
As opposed to say the popular vote.
In the Q&A, I can get into that. The electoral college is actually not a perfect space for this kind of stuff for reasons I can describe.
Okay, so this is a popular vote.
This, yeah. So, but this is. I'm just talking about legislatures at this point. So not the electoral college, but votes and seats in legislatures. Yeah.
Just a little not clear.
Yeah. So you can actually plot it out as what they call the seats votes curve, and then you can see whether that curve is symmetric around the 50% point, for instance. You can evaluate that symmetry as far out to all the way to the tails if you want to, but again, it tends to be done right around that 50% point.
This assumes sort of that you can predict the vote. That is to say, Democratic voters always vote Democratic, Republican always vote Republican, and there's no issue-based change of voting.
Yeah, so that's actually, that question of whether people vote as partisans is actually not, I would say, the biggest complication with this particular metric. It is a question mark in terms of whether the court should be involved in this area at all, right? If nobody votes on the basis of parties, there's not much point in a partisan gerrymander, and there's not much point in striking down a partisan gerrymander because it's not going to stick, right? But that's going to apply to any one of these potential metrics. Yeah.
So does this metric assume uniform?
Yeah. But there's versions that will allow for some stochastic variation around it, but as a practical matter, that doesn't really change the results very much.
But it doesn't depend on the specific candidate.
Well, it does in the sense that the outcome that you have in any particular election can be determined in part by the candidates who are running. Yeah. Yeah, and so then the assumption of this is that you can just shift that entire distribution, and again, there's some randomness to that you can insert as estimated from the data, but it doesn't tend to change that result very much. So the advantages of this, I think of this as a really good measure of majority rule. So the party with a vote majority deserves a seat majority. Symmetry tends to be violated most consistently when that doesn't happen, where if hypothetically a party lost its vote majority, it would not necessarily lose its seat majority. That actually happened in the Wisconsin plan that's at issue in the Whitford case. So in that sense, it's really great at capturing majority entrenchment. It also is very flexible about, when we talk about that aggregate votes to seats relationship, it's very flexible about what that relationship might be otherwise. Beyond basically requiring this, this majority control, it's, it says you can have a really what they call responsive system where a shift in votes, where there's a lot of competitive districts and a shift in votes produces a big change in seat share, or you can have one that's not very responsive, that's pretty flat. Anything is admissible as long as the system itself is symmetric. The disadvantage is really all around the counterfactual, at least in terms of this specific measure. As I said, we can talk about the notion of how predictable votes are by party later on. So it assumes a world that doesn't exist, right? And as you get further out from the hypothetical, the counterfactual that you're proposing, it becomes more and more misleading. If the actual vote share is 53%, flipping it to 53% the other direction or moving it to 50% or what have you is not a terribly big lift. It's not hard to imagine that might actually occur in real elections. But if a party has 60% of the vote, it's really hard to imagine that the other party would suddenly get 60% of the vote. That just doesn't really happen, and it's not clear that the plan would be designed primarily to envision that particular scenario. So it becomes more problematic as the counterfactual becomes more extreme. So is the counterfactual plausible, I think, is the big question. And this gets at what I think this particular measure emerged from. It's basically what they call the drunkard search. I don't know if you've heard this joke, but there's a guy drunk guy is searching for his wallet under the lamplight, and in this case, I guess a cop comes up and says, "What are you looking for?" He's like, "I'm looking for my wallet." And he's like, "Oh, so you've lost it somewhere around here?" He's like, "No, I lost it over there, but the light's better here," right? So the principle behind Gelman-King bias is we really know that a violation of the majority rule, right, is a pretty serious normative violation. Everybody seems to agree on that, and so that's the one sort of aggregate vote seats relationship issue that everybody seems to be on the same page about. So let's just measure it there, right? Let's measure that, even if that's not where the action really is in the system. The other potential problem with Gelman-King bias from the perspective of the courts is that the advocates for it have not offered any thresholds for saying, okay, above this point, it's a gerrymander, and below that point, it's not. How much is too much, right? This is not, in my view, an actual problem with the measure. It's a problem with the advocates of the measure, because you could conceivably offer such thresholds. They just haven't done it. Conveniently enough, these are actually also Kennedy's concerns. And he's the swing vote here, right? And so he says, this is what I don't like about Gelman-King bias. He says, OK, so this brief for one of the amici proposes a symmetry standard that would measure blah, 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 OK? We are wary of adopting a constitutional standard that invalidates a map based on unfair results that would occur in a hypothetical state of affairs. So this is the counterfactual problem. More fundamentally, you don't have a threshold. How much partisan dominance is too much? Another possible measure is to compare the mean of the districts, the distribution of district outcomes, to the median. And the idea here, just take the difference between the two of them. The intuition, the idea is that in a symmetric distribution, these two things will be equal. So this is really just, I think of it as another version of symmetry, one that is a little simpler to calculate. Yeah?
What does median mean in this case?
The district that divides the distribution in half.
So I know what median means, but what does it mean here? What is being divided in half?
The distribution of, so if you arrayed all the districts from the least democratic to the most democratic, it's the median of that distribution of district outcomes, of vote outcomes, sorry. So I think of the advantages and disadvantages of this particular measure as being almost the same as Gelman-King bias. It is easier to calculate because you don't have to actually do the counterfactual. You can just calculate the mean and the median of the distribution. But I also think the values end up being vote denominated instead of seat denominated, and so I think they're a little less intuitive. But it is a potential alternative. The efficiency gap is the one that I came up with and offered to the courts, and it comes at this from a different direction. It says, all right, well, if votes are in a single-member district system, you have a certain number of votes that are wasted in the sense that they don't contribute directly to a victory. So you have the votes in excess of the number that you need to win, and any vote for a loser. So the efficiency gap just says, all right, well, both parties should have roughly equal wasted votes. If they don't, then it means one is winning its seats more efficiently than the other. It's getting more seats for the same vote share, and that's a problem. And so the efficiency gap is just the difference between one party's wasted votes and another's divided by the total votes cast. And when you do that, it turns out that you end up with this more sort of simplified version where you don't actually have to calculate all the wasted votes. It turns out it's just the seat margin above 50% minus 2 times the vote margin. So it implies a very specific vote-seats relationship of 2 to 1. Every time you get an extra 1% of the vote, you should get an extra 2% of the seats. So it's not as flexible as Gelman-King bias is, right? It requires a particular level of responsiveness. The advantages of the efficiency gap: it doesn't require counterfactual. You can calculate it with the actual election results. And so in that sense, it's OK for competitive and uncompetitive states. Again, if you had an uncompetitive state, the counterfactual for the Gelman-King bias becomes problematic. It becomes too much of an extrapolation. And it's very good at measuring what I call efficiency, which is that if you have a constant vote share and you are winning more seats, a party should look better off under that metric. Turns out that with Gelman-King bias and mean median difference, in many cases, because of the actual counterfactual in Gelman-King bias and the implied counterfactual in the mean median difference, you can often have the case where a party can win more seats without winning more votes, and it will actually look better off, or excuse me, work worse off as a result under one of these other measures. So I developed this measure as a way of trying to address that particular problem. It also just so happens that it's a happy coincidence, not because of any sort of deeper mathematical design, the 2 to 1 seats to votes ratio actually fits the historical pattern quite well, so you don't have to ask the courts to completely undo the status quo in every respect. And we have offered potential thresholds for deciding when is too much based on the size of the and durability of the efficiency gap for any particular plan. And the size part is based on the historical record, what has typically been seen in past elections. And I've done some work to extend the efficiency gap to scenarios like variations in turnout across districts and more than 2 parties. So it has that certain flexibility to it in that sense. Disadvantages, the biggest one, I think, is that it's a relatively untested idea. And so is it really the best way or the only way to aggregate wasted votes? And I think the answer is really no. That I've seen some arguments that produce just simple proportionality, for instance, using similar kinds of principles. But again, proportionality would be problematic for the courts. But in terms of a measure of efficiency, it might be just as good. So it's relatively untested in that sense. And we don't know if there's any big surprises that might, unhappy surprises that might emerge.
Can you define wasted vote again?
Yeah, so a wasted vote is votes in excess of the number you need to win a seat, and votes cast for a loser. So they don't translate directly into a win in any particular district. So they're sort of useless in that sense, in that particular district. And it really requires a strong commitment to this idea of wasted votes. Like if there's something problematic about that, you don't necessarily want to balance that concept, right? You have to. It doesn't have the same kind of deep normative history that this sort of majority rule idea does in our system. And the efficiency gap tends to, because it works with actual election results, whereas as long as the shape of the distribution doesn't change, Gelman-King bias and the mean median difference will be immune to changes in votes over time. But the efficiency gap isn't necessarily. It can be constant as the vote share shifts, as long as it's that 2 to 1 ratio, but it doesn't have to be. And it can vary quite a bit. And I don't personally view this as a flaw. I think if you buy into the idea of wasted votes and think that makes sense as a measure of gerrymandering, relative wasted votes, then that's the variability in the metric is just a property of the underlying concept you're measuring. Yeah?
Isn't there a built-in bias that if one candidate has a very big lead, lots of his voters won't bother to show up? And that would shift the...
Yes, I suppose that's possible. It doesn't, as a practical matter, you don't tend to see that kind of dynamic at the at the level of legislative and congressional districts, turnout is driven largely by top of the ticket races.
Yes,
Yeah.
but that would affect the lower tickets because they won't show up to vote at
Oh,
all.
I see what you're saying. Like if it's a blowout, yeah, no, that could be. This metric uses the actual election results as to sort of reveal preferences for that district, which, as we're talking about, that's not 100%, right?
So maybe it's better for close elections than for blowouts.
Yeah, I mean, I think as a practical matter, the blowout phenomenon is also like people tend to turn out for a presidential election because the presidential election is exciting, for instance. And it's gubernatorial, senatorial might be a different story, but for presidential, for instance, that's not likely to be as. And of course, you could have the same phenomenon on the other side, right? If it appears like it's going to be a blowout, then the other side would be like, why should I show up, right? Yeah.
Typically, districting is the long game. It's every 10 years mandated by the Constitution that the census be taken, and shortly thereafter that the states produce districts, or at least that's what most states require. So that the geographical tie is very significant. And if you're measuring gerrymandering, you're measuring it against election results with a particular geographical partition of the state. And the question is, if you change the partition, have you introduced something which is going to make the representation, the selection of districts, voting, produce something which would be unfair in some sense? And the real question then becomes, what's unfair?
So there is this variability for as a potential issue. It's certainly something that it gets criticized for a lot. But like I said, I personally feel like it's not quite as big a deal. So the last one I'm going to talk about today is simulations, computer simulations. And this is where you basically have a computer draw a bunch of random redistricting plans. And these plans are usually constrained to satisfy some criteria, usually some sort of geographic-based criteria, like the districts have to be compact. They can't split too many cities and counties. You can also add in, and to a certain extent, you can add in minority representation, although usually the way that's done is they just take the current districts that were drawn to satisfy the Voting Rights Act, and they freeze them in place and do the simulations around those districts. And then you get a distribution of outcomes, of plans, and you can calculate for each of those simulated plans, you can calculate all these other metrics that I presented here. And then you can compare the actual plan to this distribution and see if it's an outlier. And then if it's an outlier, you can say, well, that suggests maybe the geography of the state has not dictated that this particular plan be drawn, or certainly hasn't. It couldn't have been drawn by accident. Because if you think about it, Democrats tend to, thinking about this concept of wasted votes, Democrats tend to live in central cities for reasons that have nothing to do with gerrymandering. They just like to live in central cities, and so they run up the table in districts that are drawn in those cities. And if you want to draw a district that's nice and compact, then not crazy shapes, then you're probably going to have to draw some districts that have very high vote totals for Democrats. And that ends up wasting votes for Democrats and creates a sort of natural bias in favor of Republicans, because out in the countryside, things tend to be a little more balanced between the two, tend to tilt Republican, right? So these simulations get at that idea. They say, well, OK, let's figure out to the best of our ability what that underlying geography is, so that we can base our evaluation of the plan on that. The advantages is that, well, first, it gives a pretty good sense, I think, of a state's political geography. And it also, therefore, can be a pretty good measure of intent. Because one defense might be, we were just trying to draw districts that were compact, and this biased plan emerged by accident. What are we supposed to do? But if you've got this distribution of potential outcomes, you can say, well, no, turns out that what you drew, even if there is a natural bias, what you drew is an outlier. The disadvantage is what people who are working in this area, and this is a very active area of research right now, are really trying to figure out whether these simulations really sample the entire set of potential plans. There's no mathematical proof that says that they do. The problem is extremely complex. And actually, the simulations right now, when you try to make them too complex, they can blow up. There's a woman at University of Illinois who is running these on supercomputers, and she allows all kinds of stuff to be included, not just compactness and cities and counties and freezing VRA districts in place. She's much more sophisticated than that. But at the moment, she can only do like a 100-seat legislature before the whole thing blows up. So it's a very complex problem, and it freezes, apparently. It crashes. So.
As opposed to what size legislatures does it need to cover?
So 100 would be enough for some cases, for sure. Like, for instance, California has 80 seats in its assembly. But there are some that have 150, upwards of 200. New Hampshire is the outlier. They have 400, which is crazy given the size of the state, right? So each one represents just their neighbors, basically. The other potential issue with the simulations is, can you really say that a distribution of outcomes has particular normative force? And by that I mean, let's imagine a state that's evenly divided between the two parties, 50-50, in terms of the aggregate outcome. But the distribution of simulations suggests a bias in favor of Republicans that's pretty substantial. Then let's imagine that out of the kindness of their hearts, the Republican legislature decides to draw a plan, or maybe it's a commission or something. They decide to draw up a plan that actually awards both parties 50% of the seats. Everybody would pretty much agree that that's fair. Again, going back to the Gellman-King bias idea. But if the median of the distribution is somewhere over here in a biased space, and you draw a plan that still manages, that is in that distribution, but it's out at the tails, and so it still satisfies all the criteria about compactness and cities and counties and so forth, but it happens to be an outlier, would you want to then redraw a plan that falls in the median of the distribution? And I think most people would say no, which tells you that the distribution is telling you something, but it doesn't have, independent of some deeper notion of fairness, it doesn't actually have any normative force. So as I put it here, it's like, does it matter if a plan is improbable if it's fair? If you get an outcome in the distribution, and it's out on the tails, is that a problem if it's one that in some other deeper sense is fair? And it turns out that Kennedy agrees with me on this too. He says, even those criteria that might seem promising at the outset, contiguity and compactness, cannot promise political neutrality. A decision under these standards would unavoidably have significant political effect, whether intended or not. If we were to demand that congressional districts take a particular shape, we could not assure the parties that this criterion, neutral enough in its face, would not in fact benefit one political party or the other. So if you were to, again, go just with the median of that distribution, you might end up producing a bias, and Kennedy doesn't like that idea. So where does this all get us with Gill v. Whitford? Well, just briefly about the background of the case. In 2010, the Republicans took control of the Wisconsin legislature, and they also won the governor's seat, so they had control of the whole process in a redistricting year for the first time in a gazillion years. So they were very excited. And so they decided, quite consciously, to draw a map that aggressively maximized the number of seats that they could win. And it, by all accounts, it worked pretty well. In 2012, Republicans won just 48.6% of the vote, but they got 60 out of the 99 seats. So again, not only a big discrepancy between votes and seats, but also a violation of majority rule, right?
This begs the question, this doesn't say for sure whether Republicans even had a plurality.
I think this is the two-party vote that I calculated here. So 48.6.
And so forth, there's always a few percent.
Yeah, there's always a few that are, but this is the two-party. And if you calculate all these other metrics for the Wisconsin plan, they're all really high values, all three of them. This is, so the plaintiff's expert witness, Simon Jackman, who actually used to be a professor of statistics and political science here at Stanford. He's now gone home to his native Australia, but still involved in these cases. Anyway, he calculated for all the state legislative plans over the last 40 years. He calculated the range of efficiency gap values for those plans, and this red line is the Wisconsin plan. So it's clearly an outlier in that broader historical distribution. And you can see that a lot of these plans end up crossing this zero line. So there's one of the interesting things about the efficiency gap is that while there are a lot of plans that tilt one way or the other, generally speaking, they are reasonably fair. So plans that have high efficiency gaps and don't show any indication they're going to cross that 0 point are relatively rare. This is just showing how this is based on plans that the Wisconsin legislature drew as they were working their way through the redistricting process. They started, this is the status quo map when they started, and its efficiency gap value is -3%. And then it's through time, as they drew new maps, it became more and more biased as they were looking for ways to win more seats. And the efficiency gap will, if you win more seats without winning more votes, you will always get a higher efficiency gap value in your favor. And this is the result of the simulations this guy, Joe Chen at Michigan did. So that's just the mass of the simulated values for, in this case, efficiency gap, but you could do it. He calculated it just for seat share too. And that's the redistricting plan that the Wisconsin legislature drew. And you can also see on the y-axis is the number of counties that remained intact. So it's a measure of geographic good geographic principles, right? And he did this for a number of other potential measures, compactness and splitting cities and so forth. And it turns out that Act 43 ends up down in the corner every time. And of course, you would expect this distribution to be higher up because it's designed to be that way, right? The simulations are designed to try and not split counties if they can help it. So where do we go next? Well, as I mentioned at the outset, I think there's a potential challenge here. There's a culture clash. This is a quote from the oral arguments. It happens to also quote my amicus brief, so I like to show it for that reason, because it's always nice to be body slammed by a Supreme Court justice. He says, if you're the intelligent man on the street and the court issues a decision, and let's say the Democrats win, and that person will say, well, why did the Democrats win? And the answer is going to be because the EG was greater than 7%, where EG is the sigma of party X wasted votes, blah, blah, blah. And the intelligent man on the street is going to say, that's a bunch of baloney. So he's worried about how this is going to look outside of the court. And this kind of made me think, if the court needs social science to solve a problem, as I was saying, I think they did in this case, does that mean that they can't solve it? Because simple, straightforward concepts don't need social science to be worked through. And complex concepts would likely fail Robert's man on the street test. So can the court act on complex measures without compromising its legitimacy? I don't want to dismiss. I mean, a lot of people have really dismissed Robert's comments out of hand. I don't necessarily want to do that. I think it's a legitimate question. You know, there's a question of the integrity of the court that's at stake here, and I don't think it should be dismissed lightly.
But they've given very complex legal arguments in their decisions. much more complex than any mathematical description. And I just.
I didn't say that I agreed with him.
Okay.
I just think we should take the issue seriously.
All right. Sounds phony to me.
So where do we go next with all this? Well, I'd say each of these measures has some weakness from the perspective of the courts. The Gelman-King bias and mean median difference, they have counterfactuals. The efficiency gap is very new and untested. Simulations are also relatively untested, especially in the sense that we don't know 100% for sure that they are sampling from the full range of potential plans, and they punish a party that is disfavored by political geography. My sense is I don't think there actually will be a winning metric if the court decides to intervene. My guess is what they probably would end up doing is either throwing it to the lower courts to work it out, or they would say, you know what, our standard says that all of these measures that have been presented to us need to agree, which they actually do in this case. But they all need to agree that it's a gerrymander, otherwise we're not going to get involved. And so, as a practical matter, the efficiency gap and mean median bias and Gelman-King bias, they all are highly correlated in competitive states. In uncompetitive states like California, for instance, they can very likely diverge. And so if that were the standard, it would mean that it would be harder to bring a case in an uncompetitive state than in a competitive one. So the decision is, most people think it won't come before January, and they could wait as long as till June. There are other efforts that are underway. It's not just all about this case. So there's reform efforts in terms of independent commissions like the one we have here in California, and I can talk about that if you want. Florida is one state that has legal constraints on what its legislature can draw. It says the legislature is not allowed to draw a plan that benefits one party, and there was a ton of litigation over the last several years over whether the plan that the legislature drew in 2011 actually violated that provision of the law. And I think these measures, all these measures that I've mentioned, will continue to be valuable for those kinds of things, regardless of what the court's decision ends up being.
Quick question.
Yeah.
You made a distinction between competitive and not competitive. Can you sort out the different metrics? How they have bias in terms of competitive versus non-competitive?
Well,
some sort of distinction. I could see you need some probabilistic model, for instance, to do some of this. Just to
yeah, I mean, so there's no sort of bright dividing line, but as you get further out from a competitive plan, or a competitive state, I should say, then the counterfactual becomes larger, and the potential for sort of strange results increases.
That can deal with strange results.
Yeah, I mean, I would say both the simulations and the efficiency gap can handle states that are uncompetitive. Again, as long as you buy all of their assumptions. I would not personally use the other two for an uncompetitive state at all. There's also a very interesting measure that I just saw recently called, that's even newer than the efficiency gap, it's called declination. And the idea there is you line up all of the districts in a state from the least democratic to the most democratic. And if you line them up that way, then in terms of their vote share on the y-axis, they should be pretty much aligned, more or less. It should be aligned. There should be no reason why you have an inflection point in that line right at 50% or close to 50%. And if you do, then that means somebody was really concerned about 50% when they were drawing the plan, right? And I think I haven't explored it completely, but I think it seems very promising to me. It seems like it might be a good measure of intent, in particular, that doesn't have the problem of the question of are we really sampling from the full distribution of seats? Yeah.
The intent directly by trying to make the algorithms that drew a plan more transparent rather than evaluating the plan, and then having some kind of because with an algorithm you can actually sort of describe the intent because it's clear.
Yeah. So you're saying have an algorithm replace the legislature,
or instead of evaluating the final map, like evaluate the algorithm and say like, look, this clearly was designed to be extremely.
Oh, I see. The problem is you don't necessarily know what the algorithm is that they used. Right. Yeah. So you could put something in the law that says here's how we want maps to be drawn, the exact process that it needs to follow. I actually think one of the most promising things for the simulations is as a tool, not as an evaluation tool, but as a tool for generating districts. Especially like if a court has to intervene and sit down and draw a good map in a short period of time. They could have the computer produce a bunch of maps, and then they could say, you know what, give me only the maps that satisfy this, clear this threshold on these measures, right? Sort of optimize based on the simulations, and then you would have a group that you could work from, and that's sort of like an algorithm in a sense. And you could potentially put something like that into the law as well, I suppose. And that would allow the sort of human element of redistricting to still be there, because there is an element of the communities of interest and so forth that don't necessarily have anything to do with parties, or with race or anything else, but it would allow you to sort of get that pool of potential options in front of you so that you could choose between them. Yeah.
It seems to me that districting with a geographical constraint is a significant and actually negative impact on this. This is the way by which you organize votes to be thrown away or whatever. It seems to me you could simply merge everything into a single district and then have multiple representatives from the district and allocate the representatives to a particular cohort based upon voting behavior or something on that ilk, and district things that way.
Well, I think if you turn everything into one district, I think at that point then you should switch to a different system entirely, because then you're saying geography is not what we're really concerned about. And we're admitting the parties are where it's at, and that's how a lot of systems operate, right? And then they have some decision rule for how the votes get allocated and get turned into seats. And there's a variety of different voting systems that can produce that kind of that can work in that kind of system. But once you get to that one big district thing, I think you move into that world. And as you move, because you can also have multi-member districts, right, that are sort of an in-between. Yeah. And so as you move away from the single-member district universe and start getting into larger and larger multi-member districts, I think it becomes more and more sensible to have an alternative decision rule. But the challenge is that's a really tough nut to crack in terms of reform, right? It's just because you're going to have to go through Congress in all likelihood to do that, and then that requires members of Congress to change the way that they were elected, which is tough to do. Yeah.
So I think you alluded to this, just in terms of how this case you think is going to get resolved. It'll likely be Kennedy making the decision, and how do you think he's going to feel about the efficiency gap, or what do you think is when the opinion gets released, what is the end result you think going to be?
So like I said, my guess is that they won't. That if the efficiency gap has played a role in this case, it's to make the court feel more comfortable getting involved, not offering them the Rosetta Stone, as it was often referred to derisively in the oral arguments. I don't think it's a Rosetta Stone. I think it can be a very useful metric, but and I wouldn't expect the court to want to step in, and because if they say, okay, yeah, it's got to be the efficiency gap, this thing that first appeared in print 3 years ago, right? Then they are now they are stepping in and defending it, right? Now they have put their integrity on the line, and it's not just me, right? So I would be really surprised if they took that step. Again, my guess is because all the metrics agree in this particular case, they won't feel such pressure to choose between the metrics, and they will find some way to avoid doing that, even if they get involved. Now, the other part of your question, though, I think is, what do I think is going to happen? I guess I would say going into the oral arguments, I did get to go and sit in the audience, which was fun. But going into the oral arguments, I would have probably given it maybe a 35% chance of success of the striking down the maps. But based on the questioning and in particular Kennedy's line of questioning, I'd maybe say it even tilts in favor of the plaintiffs now. So not a lot, but because this is a heavy lift for the court to want to get involved in this area. So we should never expect it to be a slam dunk.
So just a follow-up. So the 5 justices in V Jubileer said that it's justiciable, but we don't have an idea. If they are overturning these maps, then they are saying that we as partisan gerrymandering, we have found this to be partisan gerrymandering. It is unconstitutional. So substantively, would it be that they don't know, like they're not gonna pick a test? So, but how if they're not gonna pick a test, how can they say that this is?
That's a very good question. I think what the plaintiffs at their sort of at the most basic level, what the plaintiffs were asking the court to do was to admit that if there is such a thing as a partisan gerrymander, that this one is one, right? And then they were trying not to commit themselves too much to any one particular metric. At the district court level, they went whole hog on the efficiency gap, and I thought that was great and very exciting and all. But I think the strategy once they got to the Supreme Court was very sensible. It's like don't commit yourself to any one thing too much, especially because they all agree. And whether that, there is precedent for the idea of saying, you know what, we know that whatever metric we end up choosing, clearly this one is an outlier. And so we can say that there's a problem here. And that actually accords quite well with what they did in the redistricting cases in the 1960s, where the issue was not partisan gerrymandering, but it was differences in population between districts. Some districts were wildly larger than others, and the really big ones had a disadvantage because even though they had more people, they only got one representative, so they had a disadvantage relative to the small ones, and it's this massive malapportionment. And so the court intervened to force all the districts to have the same population, but they didn't decide on what that precise test was going to be for. It turns out it ends up being like congressional districts they can only vary by like 5 people, right? I mean, it became very, very tight, right? But that's not where it started out. It started out with, we think this is justiciable, and we're going to strike down this plan. And then they saw a variety of cases after that worked their way up through the courts, where they saw the full range of possible cases that were out there, and then they made their decision about thresholds and so forth on that basis. And it took them a number of years to do it. And it might be something similar with this as well. So, yeah.
I think most of what you've been addressing is the issue of statistical representation for a certain number of seats in a state, that the number in each party end up being. I think gerrymandering has been used to target individuals, either to prop up the head of the party in control or to spot the troublemakers in the opposing party and redraw their specific districts in a way to make sure they're going to have more trouble being reelected.
Yes. Yeah.
I may not have been paying close attention, but are your plans trying to factor that type
No.
of thing?
This is all about parties. There's a whole other dimension to gerrymandering that's very personal and nasty, and it has nothing to do necessarily with any of this. That's a good question. It's really like, it's important to realize what these are meant to measure and what they're not, right? And this is really all about parties and not about anything else.
And that by itself is sort of presupposing what there are some unstated assumptions here as to what you're trying to achieve, it would seem. I'm thinking there's some logic problems that have to do with things like 2 people want to split a blueberry pie. How do you cut it? And one of the answers is, well, one person cuts it in half, and the other person says which of the halves he wants. And that way, the first person is motivated to be very careful in the cutting because he doesn't want to have a choice that gives the chooser an advantage. There must be an infinity number of ways to do, many infinities of ways to do this redrawing. And coming up with any algorithm that was going to do that using some automated thing couldn't possibly factor in all the issues, like to what extent a party leader is being protected or attacked.
Yeah, and that's why I think that is never imagined to be. I mean, I guess you could try to embed that into the simulations, but it doesn't. It's.
Well, the Blueberry Pie analogy might be, instead of having some algorithm come up with the mappings, invite each party to submit what it thinks is a fair mapping, and then have an evaluation of each of the two or each of the three proposals to figure out which one's least fair and reject that, such that the person that was working towards more moderation is rewarded for taking a moderate perspective. And that would motivate both parties to have a moderate approach.
And I think, again, there is a distinction between possible reform efforts. There's all kinds of different things we could do in terms of reform, and what the courts want to do and how they're going to be involved. And the Constitution awards state legislatures of each state the right to draw the districts. So there's a certain deference that is given to them under the law. And the courts don't have the ability to invent new reforms to make redistricting work better. All they can do is impose constraints and say this one is out of bounds, right? And so it could be that in many of these cases, if a plan is struck down, the courts will decide, given the amount of time that's available, to pass it to some special masters. That happens all the time. It usually involves finding some legal expert or retired judges or something to draw the districts instead of the legislature, because there just really isn't the time to do it properly, and maybe they don't trust the legislature at that point to do it. But you first have to have that litigation to establish that you're going to hand it to a special masters. And then when you hand it to the special master could decide to do it any way they wanted to, right? They could say what you're talking about. Hey, let's get both parties to submit plans, and I'll decide the best one, or something along those lines. But the courts are constrained in sort of how they can approach this problem. Yeah.
Two thoughts, one more micro, one more macro, but they're a little related. Because this is a new space for trying to come up with objective measures and assessment, that means mostly people don't really understand it, and that includes people who are trying really hard and are really good. People generally know what mode, median, and mean are about. Well, the person on the street probably doesn't. But there's a huge population of people who do, and that comes from a long history of dealing with it. And so your point about having multiple measures seems to make a lot of sense to me. Because right now, probably people don't have a good sense of what and by people I mean more than just the people who created it. It may not have a very strong sense yet of how these different measures interact or distinguish. And so having an array of them seems like goodness, because they, to the extent they tend to agree, then they tend to make a stronger case. And so even if maybe I don't like this one that much, or I like this one too much, there's still an overall case. The larger point that occurs to me is what you've been talking about is oddly not very social. It's outcome-based, and in that sense, of course it is. But you made references to a little bit of the demographics coming into play, but they aren't really the focus. And so the nature of the people who are doing the voting and care about the outcome isn't really in the mix. And for no particular reason, I'm choosing to take Robert's concern about man on the street as a plea for what I'm afraid I have to call marketing, which is figuring out how to explain this stuff in a way that makes sense, if not to literally everybody on the street, to a large enough body of people that we have a similar degree of comfort with that as we do with mean, median, and mode, and other complex constructs.
Mm-hmm. Yeah, no, that makes sense. And I mean, I think if I were going to describe the efficiency gap, in the simplest terms possible, I would say it's about vote dilution.
About vote?
Vote dilution. About everybody having every party having their votes count the same. For the other, like the mean, median difference and government king bias, I say it's about majority entrenchment, like I said. So I think there are ways that you can describe them that maybe simplifies them. But I agree with you that there is an issue of marketing here, and I tend to not be very good at that. I like my co-author on so I developed the efficiency gap, and then I teamed up with this legal scholar to write a paper that turned it into a legal test, and he's so much better at that kind of stuff than I am, including his wife came up with the name efficiency gap. I called it relative wasted votes originally, and she's also a lawyer, and she was like, no, that's terrible. It should be efficient something else. Yeah, exactly. That's right.
There's a long game to play here in figuring out how to package this in ways that people find easy to understand and compelling.
Yeah.
So they need to both understand it and care about it.
Yep. Yeah.
So when you're calculating the efficiency gap, you're doing it like on a statewide basis, right? So
well, it ends up being statewide, yeah.
Right. Yeah.
Because it all works out the same. Yeah.
Right. So I mean, so I just want to make sure I understand it the right way. It seems to me you can envision a state where there are one or two very democratic urban centers, super geographically polarized, and there's a lot of gerrymandering in a few of those districts that just sort of lend themselves to that. But then you go out into the rural areas, and it doesn't really matter how you draw the districts; it's overwhelmingly Republican. So I'm just wondering I'm sort of wondering if this kind of overall statewide kind of measurement system, I'm wondering whether that adequately sort of takes into account the kind of geographical sorting that also contributes to this problem, and whether it all sort of averages out mathematically, or whether sometimes we might just sort of gloss over those sort of geographical differences.
Well, so the first thing is in your description, the Republican areas would have to be sort of somewhat Republican. If they were overwhelmingly Republican, then the overwhelmingly Republican here would balance out with the overwhelmingly Democratic here, and you'd end up with something that was probably pretty fair, actually, on balance. But so the problem right now in our current politics is that Democrats are packed in the central cities, and then there are a certain number of Democrats out in the countryside, but just not quite as many as Republicans. And so it's easier to draw those kind of narrow margin wins out there. So, but then getting at your larger point, I think the problem with thinking about it as sections of the state and so forth is that, again, the whole point of a party is to try and knit people in different parts of the state together into a coalition that's going to be able to act effectively in the legislature as a whole. And a party wants more seats wherever it can get them. And what it cares about for the outcomes in the legislature is the total number of seats that they have in the entire state. It doesn't really matter if they win, some here and then lose some over there. That would be considered a net zero for them. And if a plan actually does produce sort of a net zero gain, then it's not really a gerrymander, right? So I think that aggregate, when you're talking about parties, and to be fair, like there's a lawsuit in Maryland that is specifically trying to take a district-based approach and saying this district was drawn in a funny way in order to try and elect a Democrat, and that's a problem. And that's what a gerrymander is, if you have a particular district or a set of districts. And that district-based approach is more in line with the way that the courts have thought about other kinds of gerrymandering in the past. So racial gerrymandering has typically been thought of as specific districts. So this district was drawn to be a racial gerrymander, right? And not an aggregate thing. And that came up in the oral arguments. It was one of the questions that there's a question of standing in this case, where the court wants to know, is it even appropriate to bring a statewide claim? Or does a claim about gerrymandering have to be district specific? And the answer that they gave, and the answer that I would give, is that, again, parties are inherently an aggregate concept, and people who are in the central cities care about how many people are elected from their parties out in the countryside because they want their party as a whole to do better. Even if they themselves are in a district that's nice and compact and that elects a candidate that they like and that's of their choice in that sense, that you really do have to think about it in those broader aggregate terms. But that might be another way in which it's a non-starter for the courts. That might be one of the way that they would decide this case, in fact, is to say, you know what, it's got to be a district-specific thing. It can't be an aggregate approach. Yeah.
Could you say something about the way California does it? How does this commission get created, unbiased?
Yeah. So
how do they decide whether a map is good or bad, or how do they make a map? Or?
So the commission was created in the latter part of the last decade and was used for the first time in 2011. The process for picking the commissioners is very complicated. It starts with the state auditor who submits, who requests applications from anybody who's a registered voter in the state. So the first time they had this commission, it received like 30,000 applications. The state auditor had to go through all those and figure out and whittle it down. And so then they whittle it down to a much smaller pool. They interview that smaller pool, and then they whittle it down further. And then they give the members of the legislature a chance to strike a certain number of names from the list. And then once those names are struck and they have their final list, then they randomly choose the first 9, I think, of the 14 members of the commission, and then those 9 choose the remaining members. And then the process of it is they have to hold open meetings. Everything's got to be open and transparent. To me, one of the biggest things is they have to produce a report at the end that describes why they drew each district the way they drew it. And that is, I think that is undervalued as one of the, pluses of this kind of system. Like if the legislature had to produce a report that said why they were doing what they were doing, it might be easier to attack them, in litigation. Whereas when it came before the California State Supreme Court, the state Senate map that was drawn by the commission ended up before the state Supreme Court, and they just went through that report, and they were like, well, it says here they drew it this way and this way, They had a record, they had a justification, which is a very sort of judicial concept, right? And so I think the judges really liked that. There also are some criteria in the law that require that the districts be drawn with certain issues in mind, and those issues are ranked. So it starts with equal population, then it goes to the Voting Rights Act, then it goes to like keeping cities and counties intact, and all down the list. They actually says that they can't consider partisan data when they're drawing their districts. So I actually think that, depending on what the court rules, that might be something they want to reconsider, because if you had a standard for, the court offers a standard for how you avoid partisan gerrymandering, it seems to me the commission should just embed that standard in their law and actually use the partisan data to do that. But so then it's a very open, transparent process. I was a little skeptical that it could work, but I'm kind of a fan now. So, yeah.
I'm kind of a total numbers geek, and I mean I really play with numbers. I venture to say I could make a map that would make any particular one of your metrics shine wonderfully and the other ones shine bad, or make them all shine good, or make them all shine bad. What you've described to me is a system that is inherently biased because it's made with people that all have, no matter how randomly you pick them, it's all geographically based or racially based or school based or something like that. What about a totally random number generator based pseudo-random map that would totally randomize it so that all metrics were great, or all metrics were terrible, or all metrics were how you wanted them?
Well, so I think having a metric-based approach makes a lot of sense. And like I said, I think the way that I would prefer to do that is to have a computer generate a bunch of possible plans that were optimized on, on a bunch of metrics jointly, and then.
Pseudo-random, meaning you randomize it so much that metrics, you pick all the metrics you want, but you get all the metrics to be what you want based on the sort of randomness.
Yeah, and then, but then I still think there should be a part where you, once you've decided that all the maps that you got in front of you are acceptable on all the metrics, then you get to choose between them, and you don't have just one choice. Because there are other elements. I actually think one of the things that was sensible about the commission is that it had a requirement that communities of interest be respected, and communities of interest for as it played out in the commission's work just basically meant whoever shouted the loudest, right? It was whoever showed up at the hearings and said, "We're a community of interest. We need to be respected." But you know what? When you're passing a law, which is what the commission was doing, you want to take into account passionate interests. If you don't, you're going to be in trouble. You want to know who cares the most, and you want to try and accommodate their interests to the extent that you can without doing violence to a lot of other groups. I mean, that's a lot of what our system of government does, is trying to make sure that the most passionate voices are satisfied without doing violence to everybody else. And that sometimes works and it sometimes doesn't. But
so you're really blending multiple metrics.
yeah, and I mean, I think
in optimization theory that shows up, except there's one little caveat in there that typically you have to have at least one strange metric, like indefinite or whatever. There's a thesis if I want to read the math, but no, but that's basically the bottom line. It's multiple metrics, but at least one of them is odd in some sense.
Yeah. We're running out of time.
Okay.
So I want to thank you very much. We'll continue the discussion down here. Thank you very much.